Ms. Smith, are we live? Ms. Smith or Ms. Dean, are we live?
Shows we're live. It popped up live.
Okay. Okay, let's go ahead and proceed.
Thank you, Your Honor. Earl Nesbitt on behalf of Dallas County Election Administrator Michael Scarpello and the Elections Department. With respect to the substantive arguments, as I said at the TRO hearing last week, really we don't have a dog in that fight because our role is to administer the election based on the certified candidates provided to us by the municipality or the school district. Unlike in partisan elections where the parties determine who the candidates are, here, these nonpartisan elections at the school board and municipal comes from the city, who contracts with the election administrator. So ultimately, we take our cue from the people we contract with to administer the election, in this case, the city of Farmers Branch. In this case, the city of Farmers Branch has determined that Ms. Munoz was not an appropriate candidate, and therefore that's how we are appearing. Again, we don't know the underlying facts other than what has been stipulated to. We weren't involved in the application process. I will just note that under the law, the candidate, the burden for complying with the application under the Texas Election Code, the requirements for being a candidate, falls squarely on the candidate.
I apologize. Let me take a quick break. I apologize.
Certainly.
Sorry about that. Let's go.
That's okay. What I was saying is under the law, under the election code, and in the case law interpreting election code provisions, the candidate ultimately bears the ultimate burden for making sure that their application complies with the law. So even if they follow the instructions, whether misguided or wrong, of a government official in preparing that application, if it is in fact deficient under the statute, then they bear the burden. So to the extent that all of these issues relate relative to somebody told me to do this person who could have been a clerk or may have been an administrative assistant, at the end of the day, if the application is deficient for whatever reason, as such that the candidate is not appropriate under the election code to be listed on the ballot, then I'm afraid that falls ultimately on the burden of Ms. Munoz. Having said that, you will determine those questions, and I don't argue with counsel about what those legal two questions of law are. I think those probably make the most sense, although I haven't studied it as much. Our position remains that, unfortunately, at this late stage of the proceedings, this court does not have jurisdiction to decide this case. We filed a plea to the jurisdiction in original answer. We would echo our arguments made to the court last week. Those arguments, just for the record, are that the candidate has the option, if they want to challenge the application process having been denied, the application process, to seek a writ of mandamus directly with the Court of Appeals. We believe they should have done that at this time. And the reason for that is because the case law makes clear that when someone is seeking interlocutory or injunctive relief, they have to, although the statute allows them to seek appropriate injunctive relief, appropriate injunctive relief is not appropriate when under 273.081 of the Election Code, if it's ordered by the court, it does not provide the parties the opportunity to obtain a final decision. Of course, the court has determined we're going to have a trial today, so you're going to provide a final decision, but that's not it, or to permit meaningful appellate review. And in this case, we believe that having this trial, this challenge to the application process this late in the process, even though we still have a few days before the deadline for sending out applications, does not, and even though the court is going to give a final judgment, it sounds like today, that still does not provide the losing party, whoever it may be between the city and or the candidate, the opportunity to seek meaningful appellate review or a final appellate revision. We believe that the candidate, in this case, Ms. Munoz, should have taken the opportunity provided by the election code to go directly to the Court of Appeals, and we could be having this hearing in the Court of Appeals. And in that way, I think they could have complied with the requirements. But under the law as it exists and under the facts and the timing of this particular challenge, we believe that the issue is moot because of the inability of the court to provide both the final judgment and the opportunity for meaningful appellate review. And for those reasons, we would ask that the application and petition be denied for a lack of subject matter jurisdiction.
Okay, I'll go ahead and rule. I'm going to rule in favor of the plaintiff on this, deny the motion, the plea to the jurisdiction. I'm not going to award costs against the City of Farmers Branch. I think they were just doing their ministerial duty. So, Mr. Lee, you need to provide a new judgment on that you can email to Rhonda. I guess the one other issue is, do you want to include the alternative grounds of the right? I don't have an opposition to giving you the right to cure as well. I don't know if that's helpful if I'm ruling for you on the other points. I don't know if there's going to be an appeal or how you want to do that, Mr. Lee.
I don't need the alternate grounds. If the court signs the final judgment as it stands. If there were to be an appeal,
it needs to be changed because I'm not awarding costs against the City of Farmers Branch. So give me a new judgment.
I'm working on that as we speak.
Okay, sounds good. All right, actually, I'll just handwrite it in and submit that because I know we're kind of short on time. So, all right. Anything else, guys?
No, you are not by the city defending.
Judge, I can email this to Ms. Pinson or Ms. Rieger immediately. I've got it.
You can go ahead and email it to Ms. Pinson. All right. Anything else, guys?
No, sir.
Negative, Your Honor.
All right. You guys be safe and